Hi, I'm Paul Malice, partner in the law firm of Young, Marr, Malice and Associates. Welcome to the Paul Squared podcast. I started my career in the district attorney's office, and in 2016, I turned my focus to exclusively defending clients charged with crimes. I created this podcast to provide an overview of the criminal law process and to answer the questions I most often get when I first meet prospective clients. My goal is to protect my clients' rights and to guide them through the stressful process of being charged with a crime. While this podcast serves to provide general guidelines around the practice areas we discuss, you should always consult directly with an attorney to make sure the specifics of your particular situation match up with the applicable laws. The decision of choosing an attorney is an important one, and you should give it careful thought before deciding. If you need representation or just have questions, please don't hesitate to contact me at 215-639-5297, or you can visit our law firm's website at www.ykacrim.com. That's ykacrim.com.
I'm here again with Paul Malice. Welcome, Paul.
Thank you. Thanks for having me again.
Absolutely. So today's episode, we're going to focus on DUI charges, DUI being driving under the influence charges. I know it's a typical charge that is out there. You see people just because of how many people drive. Unfortunately, there's a lot of drinking and driving, and people get arrested for that. So it's a fairly common charge that's out there. And so we decided that one episode would make sense to address the issues and questions that arise out of that. So let's jump into this and start with, if someone's pulled over for a suspected DUI, what should they do?
So I always want to start off with, you want to be polite and respectful. You can never go wrong with being polite and respectful. Having said that, though, you need to be aware of your rights. What a police officer is going to do in establishing a DUI type situation is base his or her opinion that you're driving under the influence. They're going to base that opinion in part on their observations of you, the driver, the physical observations, and they're going to administer what's called field sobriety tests. And those field sobriety tests are designed to see whether or not you are impaired. They are objective tests that police officers are trained and experience it in administering, and they measure whether or not somebody's impaired. So police officers, they need to render an opinion that you, the driver, you're driving under the influence of either controlled substances, alcohol, or both. And in rendering that opinion, they're going to base their opinion, at least in part, on their physical observations of you. And they're going to administer what's called field sobriety tests, which are objective tests used to see whether or not the driver's impaired. You do not want to agree to submit to field sobriety tests because without them, the police officer is not going to be able to state with particularity and with specificity that you know how well or not so well you did on these field sobriety tests. And there's no penalty that could be held against you for not performing these field sobriety tests. However, there are penalties that can be imposed for refusing to submit to chemical testing. Chemical testing is totally different. We are what's called an implied consent state here in Pennsylvania. That means that by virtue of driving on the roadways and the highways in the Commonwealth of Pennsylvania, you are giving implied consent to submit to chemical testing anytime you're arrested for suspicion of driving under the influence. If you refuse to submit to chemical testing, blood or breath, then PennDOT will administratively sanction you with a license suspension right off the bat. So I want to be very clear, you don't want to refuse to submit to chemical testing. You can and should refuse to submit to field sobriety testing. Two vastly different things.
So you're pulled over, license and registration. Have you been drinking? The typical line of questioning that you can imagine is going to happen with the stop along these lines. They say, hey, we'd like to do a field sobriety test for you. what should you say? Like you said, you want to be polite and everything like that. What is your proper answer to them?
Look, here's the situation. You're pulled over for running a stop sign, or you're pulled over for weaving in the roadway. Police officer approaches your door, license and registration. You crack the window a little bit so that you could speak to the officer, and you hold up your license and registration and your insurance information to the glass, or you feed it through that cracked open window, and you politely answer questions that are asked of you. Will you do field sobriety testing? No, I will not. Where are you drinking? I am not answering the question. Where were you coming from? I'm not answering the question. Where are you going? I'm not answering the question. You can answer the question without answering the question. And then the police officer is kind of limited in what he or she could do at that point in time. You're not getting out of the car. You're not refusing to cooperate or answer questions. You're just not giving them information that they can rely on in effectuating a DUI type situation. That's the perfect type situation.
Are you pretty much guaranteeing they're going to give you a breathalyzer or take a blood draw at that point, or is it a crapshoot depending on if they say, hey, I don't have access to this or whatever, maybe they'd let you go on your way?
If you're not getting out of the car and the window's only slightly ajar, and there's no odor of alcohol that could be detected, and there's no odor of controlled substances, marijuana or any other controlled substances that would render an odor, they really don't have too much to base their opinion on other than maybe driving observations, weaving in the roadway or traffic violation. They really don't have too much to go on to make this a DUI type situation. So why give them further information by getting out of the car, by giving field sobriety tests? The breath test, what we call the PBT, the portable breath test, or oftentimes called the preliminary breath test, that's a roadside test. That's nothing more than a field sobriety test. You should refuse to do field sobriety tests, including the PBT, the portable breath test, just not chemical breath testing. We don't even get to chemical breath testing until we go through these field sobriety tests. An officer needs to be able to establish, probable cause to make an arrest here, and to get to that point where we're giving a chemical breath test or a chemical blood test. They need to go through those first motions, those first steps.
So basically, anything they would be asking you to do on the side of the road, pulled over, are all things you could legally refuse to do, and they have to decide whether they have enough information to arrest you and take you into a station or a hospital where a chemical test, whether it's breathalyzer or blood draw, would be mandatory at that point, unless you want to lose your license.
Right. But again, at that point, again, the situation is, simple traffic infraction. You're pulled over for, you're opening the window slightly ajar. You're providing them your driver's license information, your documents. Short of that, I mean, if you're physically removed from the vehicle based on nothing more than a traffic violation, that could be a real problem for the prosecution. Gotcha. Which means that if they do obtain any further information, any further evidence, that can be ruled inadmissible at trial.
So this is all sort of setting it up to say, look, is something that they did enough for them to have taken the next step? And if it wasn't, then you can say the next step should have never happened.
Correct.
Okay. And I think you already mentioned this, but if someone refuses to take the chemical tests, and it's a distinction, not what they're giving you on the side of the road, but what they would be doing back at the station or at a hospital, that's when you automatically lose your license.
Right. So what happens is, let's say that, okay, you're taken to the police department for a blood draw, or you're taken to the hospital for a blood draw or a chemical breath test in a machine, and you refuse. You're going to be read what's called DL-26 implied consent warnings. And those warnings, in short, are, I suspect that you're driving under the influence. I'm requesting that you submit to chemical breath or blood test. You do not have the right to speak to an attorney. If you refuse, to submit to this test, you lose your driving privileges. If you refuse the chemical test at that point, it's a license suspension automatic. And usually when clients hear you don't have the right to speak to an attorney in this instance, that triggers something and they say, well, wait, something's not right. And then they refuse. The law unfairly, albeit still requires a license suspension in that instance. What happens from there is when the client receives notice of the suspension because of the alleged refusal, they do have appeal rights. Client could appeal the license suspension on the basis that that the police officer did not have reasonable grounds to suspect a DUI, and the driver was not given a meaningful opportunity to submit to chemical testing, or the driver did not make a knowing and conscious refusal of chemical testing. It's a very, very difficult standard to meet, but the driver can appeal the license suspension, the refusal, and would have to just meet that standard.
And you say, all right, so if they're given these warnings, they're brought in for the chemical test, and they refuse to do it, there's an automatic license suspension. How long are we talking about?
Depends. It depends on which DUI offense it is. If it's a first offense DUI, it's a 1-year license suspension. If it's a second DUI offense, it could be an 18-month license suspension for the refusal. So it just depends on which number DUI offense it is.
Okay. And does refusing to take any of the roadside tests, whether it be the breathalyzer they bring up to the car, or the what do you call it again when they're making you walk on one leg or hop on
the field sobriety test?
Field sobriety test. So does refusing to take either one of those put your eligibility for ARD at risk at all?
For ARD, no. But generally speaking, no. But if it becomes such a combative type situation where the officer makes a DUI arrest, despite your not completed any of the field sobriety test, the officer could object, could tell the district attorney, look, this client was combative, was uncooperative. This client should not be afforded the ARD opportunity. Then in that respect, it could affect your eligibility.
Because as we discussed in prior episodes, the determination of ARD eligibility is left completely up to the DA. So they have that discretion of whether to give it to you or not.
Right. And if their cop in the case is saying that they object, he or she objects to ARD, then the district attorney is not going to override the officer's objection.
Gotcha. So what happens if someone's driving high, whether it be from marijuana, pills, otherwise, and how does law enforcement determine impairment in that situation?
Sure. We have, well, first of all, you can't drive high. Driving high is the same thing as driving impaired, or the same thing as driving impaired under the influence of alcohol. If you're driving while impaired of a controlled substance, then you could be charged with DUI. There are specific tests that are used with regard to drug DUI offenses, and those are called drug recognition evaluations, or what we call ARIDE, which are specific tests used that are designed to detect impairment of controlled substances, and the officer needs to be trained and certified in rendering those specific tests. So I've had cases where it was a controlled substance type case, and the officer administered standardized field sobriety tests, which are tests designed to see if somebody's under the influence of alcohol, when really it was a controlled substance case, and the client was charged with DUI of a controlled substance. So that's a defense in a type of DUI case. So the officer needs to administer the correct type of test based on what the officer believes the driver is under the influence of, and the officer needs to be certified in administering these tests.
And these tests, are they similar, like you said, to a field sobriety test, or could you describe, or do you know how these tests actually look like when they're being administered?
Sure. Usually standardized field sobriety tests are what we call one-legged stand test or a walk and turn test. They look at pupils. We call them horizontal or vertical gaze nystagmus tests, which looks to the pupils to see if there's lack of smooth pursuit or any, for layman terms, eye jerking movements. We use a pen. Those are standardized field sobriety tests. And those also could be used in addition to the drug recognition evaluations in controlled substances or drug DUI cases, but they're always used in alcohol-based DUI cases. So those are standardized field sobriety tests. We also have drug recognition evaluations that are used, which are more so focused on hand-eye coordination. Those are the types of tests that are employed when it's a drug type DUI offense.
Gotcha. Okay. And does having a medical marijuana card, because that's a fairly recent, availability in Pennsylvania in particular, but does that protect against the DUI charge related to driving under the influence of marijuana?
In short, no. No, you cannot, and the operative words that you use are under the influence. It's just like alcohol. Alcohol is legal if you're 21 years of age or older, but you can't drive while impaired by alcohol. Same thing with marijuana. Marijuana is legal if you have a valid prescription under the Medical Marijuana Act, but you can't drive while under the influence or while impaired by that marijuana. So that's one piece to it. But the current state of the law says that any amount of a Schedule 1 or 2 controlled substance is per se categorically driving while impaired. That law means that even if you have a valid prescription for marijuana, you are still driving while impaired if you have marijuana, prescription or no prescription, in your blood. Will that law change? Has there been discussion amongst the legislature in changing that law? Yes. But as of today, December 2024, that's the current state of the law.
So if they detect one iota of marijuana in your system, you're considered impaired.
It's not that cut and dry. We measure it by what's called, the metric that we use is nanograms per milliliter. And we look to what's called delta 9 THC. That is the active ingredient in marijuana that gives that euphoric or high or impaired feeling. And so we look at how many nanograms per milliliter of delta 9 THC, the active ingredient of marijuana, how many nanograms per milliliter does the client have? And the test that's used will have a reporting limit. So if you're under that reporting limit, then obviously nothing's going to be detected. Well, that reporting limit's very, very low. It depends on the county crime lab that's used. But if you're over that reporting limit and you have the active ingredient of marijuana, then you're per se driving while impaired.
And and I think you mentioned this, but want to make sure I have it correctly, that if, however, you have another illegal substance in it's not something you can get by prescription, it's not something that you can have a marijuana card for, it's cocaine, it's heroin, it's whatever it might be. If that's in your blood, that's an automatic impairment.
Right. That's an automatic impairment as well. And that's why it says any amount of a Schedule 1 or 2 controlled substance. Really, I think the theory behind it is that the legislature was intending for illicit substances, and perhaps when the statute was enacted, marijuana was an illicit substance. Well, now in today's day and age, it's become legalized more and more across the nation.
So they just haven't necessarily changed the laws to catch up to what the practicality is out there.
Exactly.
Okay. So we talked about marijuana and illicit drugs. What about someone who may be taking prescribed prescription drugs, but have the ability to make you drowsy or impair your ability to operate machinery, or those different types of things you see? What happens if you're pulled over and you aren't, no alcohol, no marijuana, nothing else, you're only on a prescription drug, but they think you're impaired?
And that's the key. No other substances, alcohol or the combination of any other substances, because that could render somebody impaired. So that's the key. So we're talking about solely prescription medication. We look to something called the therapeutic range, and we look to the longitudinal picture of the client's medical history. How long have they been prescribed the medicine? What's the dosage that they've been prescribed? We see this oftentimes in the context of Suboxone or methadone or some sort of other opiate blocker. We see it in the context of benzodiazepines, in the context of other types of prescription medication that are controlled substances. It just depends. Therapeutic range means that you have a certain amount of that controlled substance in your bloodstream that's within the range that would not impair your ability to drive. Some experts will say that despite the fact that you're within that therapeutic range, you could still be impaired. And then a case really comes down to what we call battle of the experts. So I won't go too much more into that, but the short answer is you could still be impaired and charged with DUI, even if you're on prescription medication and only prescription medication.
Gotcha. And so if you're on prescription and alcohol or prescription and marijuana, then sounds like it becomes much more difficult to argue non-impairment because you are purposely or you've taken multiple things that could cause impairment, and they're probably going to frown upon that.
Right. I mean, let's say that you're on prescription Adderall and you've been drinking. Both are legal. You have a valid prescription and you've been drinking, and perhaps you had one or two beers, but it's the combination of those two substances that can render somebody impaired. So it just depends. Every case is different. No two cases are the same.
Yeah. So this might seem a little out of left field, but I know it's something that's happened before, and so I wanted to put this question in here. But can somebody be charged with a DUI if they're sleeping in their car and they weren't actually driving? So you get out of the bar, you realize you're too impaired to drive. You say, you know what, I'm gonna go to sleep in my car and just sleep this off. And you're in the bar parking lot, and the cops roll up. They see you in there, shine the light on there, and ask if you've been driving. Could you be arrested for a DUI at that point?
Of course, you can always be arrested for a DUI. It's whether or not the charges are going to stick. That's the perfect type of situation. Obviously, in order to be guilty of DUI, you have to be driving, right? Driving, though, is broadly defined under Pennsylvania case law, and it can mean that you're in what's called actual physical control of a motor vehicle. Actual physical control can mean that the driver is slumped behind the wheel of the car, keys in the ignition. It can mean that could rise to the level of driving for purposes of being charged with DUI. But the law says that something more is needed than a driver sitting behind the wheel of a parked vehicle with the key in the ignition. There has to be some evidence that the vehicle was actually driven while the driver was impaired. So in your situation, client leaves the bar, gets behind the wheel of the car, realizes that they're too drunk or too impaired, and then they pass out, and then they're arrested for DUI. Well, where's the evidence that the client actually drove the vehicle? The client was at a bar, that bar served alcohol, then the client left that bar, but never moved the car. In that type of a situation, there's no other evidence except for the client sitting behind the wheel of a parked vehicle. And so I would argue that there's no DUI. And so we see that type of a situation a lot. And the best type of a fact pattern for this scenario would be outside of a bar or some other establishment that actually serves alcohol. That would be the best situation.
Well, so let's expand upon that a little bit further, because this is kind of the next question. But let's say leave the bar, get in the car, drive the car a mile down the road and realize I'm too drunk to drive, pull over on the side of the road, and then go to sleep.
Nah, that's different. Yeah.
That gives you that added element. Do they have to see you driving the actual car to say you were you weren't?
No. The officer doesn't have to see you driving, but one could reasonably infer based on the location of the vehicle that the vehicle was actually driven. And there's a case on that. As ridiculous as this sounds, however old the case is, the client, the driver's vehicle was in the middle of a basketball court. Well, how did the vehicle get there? It was actually driven, right? So similarly, I think that's a very uncommon example, but we use that case as the classic textbook example. More commonly, what we see is the client's pulled over on the side of the road, or the client is stopped at a stop light with the foot on the brake and they're passed out. Obviously, the vehicle was driven, and so one can infer based on the location of the vehicle that the vehicle was actually driven.
And I'm sure it gets a little more cloudy, but if they're not in the actual car at that time, let's say, again, same situation, but someone decides, I'm in Western Pennsylvania, so I'll use Sheetz as the example, but I know it's Wawa for you Eastern PA folks. So
it is Wawa for us.
Exactly. Sheetz is better, but I'm not going to get in that debate with you. Anyway, so if you leave that bar, you go to Wawa, you park, you're now inside there, and they didn't see you driving the car. You're, whatever, but somebody's reported that you were out there. Can they still
Driving,
get you?
right? The person reports that you were driving recklessly, and then the police get there and they see your car's parked and you're inside the Wawa or coming outside the Wawa. I had this case a while ago. It involved controlled substances. And if I'm not mistaken, there was a baggie that was found in the trash can of the Wawa, inside of the Wawa. So wasn't the argument that the client parked the car, went inside the Wawa, took his drugs, and then left the Wawa to go drive, but never drove? So if all those facts were true, and I'm not going to say whether or not they were or not, but if all of those facts were true, wouldn't that mean that the client's not driving for purposes of the DUI statute, or not driving, took the drugs or was impaired prior to driving? So that's a very specific fact pattern. But let's modify it a little bit. Let's say that the 911 caller calls and reports a reckless driver, who just parked inside of the Wawa. Here's his tag number. And then the police come and they see that the vehicle's there at the Wawa, but the driver's not inside of it. But we look to the position of how the vehicle's parked. Let's say that the vehicle is taking up 2 parking stalls, or the vehicle is parked crookedly, or it's not even in a parking spot. Again, not direct evidence of driving, but one can infer that it was driven while impaired due to the location of the vehicle.
So basically, there isn't some silver bullet of, hey, you weren't in the car, or even though your car was away from where it originated. The inferences that the police can make in terms of connecting the evidence together can be enough for them to make an arrest.
Sure, we call it circumstantial evidence. It has the same weight as direct evidence, but it's thinking outside of the box and making reasonable inferences, and it holds the same weight as direct evidence, meaning that the driver was seen driving.
Gotcha. So is an underage DUI more serious than a regular DUI?
It increases the client's exposure. The license suspension is greater than if the client were was of 21 years of age or older. So in that respect, it's more serious. It increases their exposure for their license suspension.
Gotcha. So it's just basically an additional layer of charges that can be brought against them, but not necessarily
Correct.
more. Okay. What circumstances make a DUI charge more serious? Can you give some examples of, all right, someone's been pulled over for DUI, but here's some extenuating circumstances that are going to lead to potentially more serious charges?
Classic example is kid in the car, underage kid in the car. That increases the penalty. It increases the client's exposure. It could lead to child endangerment or reckless endangerment type charges. It drastically changes the dynamic of the case. If the client's never been in trouble before and there's a child in the car, when I say child, I mean somebody who's under the age of 18. So even somebody that's 17 is considered a juvenile, a child, under Pennsylvania law. that drastically changes dynamic. And even if they've never been in trouble before, because there was a child in the car, they don't qualify for a first-time offenders program. So that's one example how that would be an extenuating circumstance that could affect the client. Another example, there's an accident, an auto accident that occurs. That raises a red flag. To the district attorney prosecuting the case, it raises a red flag to the judge presiding over the case. So those are some circumstances where the dynamic, it's a little bit different than the typical DUI situation.
And can a DUI ever rise to the level of a felony, which we discussed previously is the most serious of offenses that are out there?
Sure, definitely. If it's a third or subsequent DUI offense, it could be a felony. It could be a felony if it's a vehicular homicide while the client was driving under the influence. That's a felony. So there are circumstances where it's not just a simple misdemeanor type DUI offense, but now the dynamics change depending on the extenuating facts, the extenuating circumstances.
Okay. And I think you mentioned in, again, previous episodes that, hey, if this is your first time DUI offense and you don't have these extenuating circumstances, there's a good chance you could be eligible for ARD. And I think you mentioned this, but I'd like to confirm with you that it's rare in your experience that someone with a first time DUI, again, without kids in the car, without an accident or somebody hurt or something like that, is it going to end up going to jail? Is that fair to say?
It's rare if it is a first offense, if they would go to jail.
Yes.
Meaning that if it's a first offense, they're going to qualify for a first-time offenders program.
Yeah, or that, I think you had mentioned previously that if someone's arrested for a DUI, and again, it doesn't have all these extra factors around it, that they may be taken to the station, but they're not going to be, they're arrested, but they're not going to be put in jail. They're probably going to be let go right then and there, and they're going to have to come back and deal with the charges later, but they're not going to be likely sending jail time right then and there.
Right. That's a fair statement. That's a fair statement.
But absent them, even in an ARD situation, it's pretty likely they're going to lose their license for some period of time if you haven't proven out that the DUI stop shouldn't have happened or your client wasn't drunk or something like that.
Yeah, I mean that period of time, it depends on what the client's blood alcohol concentration is, or whether or not they have controlled substances in their blood. So the length of the license suspension really just depends on what's in your blood at the time of the DUI arrest.
Gotcha. But even for like the lowest punishment level in ARD, there still is a certain amount of license suspension, even at there.
Yeah, so if a client is approved for the ARD program, the length of their license suspension still depends on what's in their blood. The longest period, the suspension could be 2 months or 60 days. The shortest period is 0 days. It just depends on what is in the client's blood at the time.
Gotcha. And let's say someone is convicted for getting ARD for a second. Have you seen where judges will let someone drive for work or school if their license has been suspended?
It's not really a judge decision. That's the one type situation where the judge has no authority. That's a PennDOT, that's a Department of Transportation issue. And the PennDOT, Pennsylvania Department of Transportation, does allow for limited license. We have what's called an ignition interlock limited license. And in DUI type situations, a client will qualify for the ignition interlock device, which is a device that's installed in the client's vehicle that they blow into that allows them to drive on that limited license. The question then becomes, is there a waiting period until they'll qualify for the limited license? And that answer depends on what number DUI offense it is. If it's a first DUI offense, they qualify immediately. If it's a second DUI offense, there's a waiting period until they qualify.
Okay, so it may be possible that someone can get this, but they may still have a period of time where their license is suspended before they can even see whether they can get one of these limited licenses that would allow them to drive in certain situations.
Correct.
Okay. And have you seen, generally speaking, does a DUI cause someone's insurance to go up?
Depends. I always say, I mean, it depends on whether or not there was an auto accident, a crash that occurred. Very rarely do we see insurance premiums increase on the mere fact that there was a DUI arrest. Insurance companies very rarely are made aware of a DUI. Usually, insurance companies are going to get involved if they're doing a risk assessment and they see that there was a reportable crash that happened. Then you're at an increased risk, and so you're at an increased premium, but not just because of a DUI. It's very rare.
So a suspended license, for instance, without an accident involvement doesn't necessarily get automatically reported to someone's insurance.
I don't know if it automatically gets reported. That I couldn't answer that question. I'm not sure if it's automatic.
Gotcha. So I think we're coming to the end of our podcast session about DUI. So I'm going to ask you a general question to sort of wrap this up. So if can you explain just generally why someone should consider hiring a DUI attorney, particularly if it's a first-time offense, and if they should consider, at what stage should they consider hiring somebody? Could you just sort of wrap us up with those two points?
Sure. Well, you always want to have an attorney at the initial outset of the case right away, somebody who will advise you. I do sometimes get the question, look, why do I need a lawyer if I'm just going to be going through a first-time offenders program? It's the same question, that you can ask, why do I need to hire a mechanic if I know how to fix the issue with my car? Because you want to have a trained and experienced professional that's going to be help you navigate through the process. And, even though you're going to be going through a first-time offenders program, you're still going to be going through a preliminary arraignment and a preliminary hearing and a pretrial. You're still going to need to know the rules and the proceedings that you're going through. And so in that respect, that's why it's always best to have a trained and experienced professional help you out.
And again, if I heard you correctly, your opinion would be that you want to get, if you're going to hire an attorney, you want to get them involved as early as possible.
Correct. As early as possible. And oftentimes we get clients who were arrested the night before who contact us. Charges have not been filed yet, but they've been arrested for DUI. That's great because now we can get that client on board and we can have boots on the ground, so to speak, right? So we're getting them through our onboarding process. We're checking the court dockets every single day. So that way, when the client is charged, there's no surprise. They already have counsel. We already have things set in place. We can move forward. We can move forward at that point in time.